So welcome to week 1 of corporate and commercial term 2. So basically today we are dealing with intellectual property rights. So most of you are intellectuals, so I believe that this is going to be a very good discussion. So the law on intellectual property is governed by the Act. So the Act is very clear. If you read the Trademarks Act and you read the Copyrights and Neighboring Rights Act, the law is really very clear that it will not leave any doubt in your mind. So I implore you to read those two acts, and it does not matter whether you did intellectual property at your undergraduate, because the law is really clear and straightforward. And a good lawyer must know where to find the law, but also a good lawyer must be adoptable. You must easily adopt, because if you get a client and your law firm is about to close, and the client is coming and giving you 100 million to do intellectual property, you must be in position to adopt and take up the case and rescue your law firm. So let us begin. Under this module, we are introducing students to various aspects of intellectual property registration, and the rights that accrue from such registration. So basically we shall look at what is intellectual property, and basically how is it registered under the Act, because the Act gives you the process of how you can do to register what we call intellectual property. So we shall handle trademarks. Basically when we talk about trademarks, we mean signs and symbols which are adopted or have been registered by companies. So under the Act, when you look at Section 1, registered trademark means a trademark that is registered under Part 3 of this Act. But the trademark can be maybe a symbol. We all know Benz, and when you look at that symbol of Benz, you know that this is a Benz. We have seen the trademark of Tesla. We have seen the trademark of BMW. So most especially cars, Toyota. So all those ones have trademark, and that's what we shall be looking at. Then we shall look at copyrights and neighboring rights. So basically when we talk about copyright, we mean written material like books. If you have authored a book, then you have a copyright, and then neighboring rights, which basically extends to protect the rights of musicians and broadcasting rights. So we shall look at image rights. For example, can I take your photo and use it on this YouTube channel without your consent? And also industrial designs. So the law gives a person rights to a certain intellectual property that they create. The law allows a person to protect original ideas and prevent unauthorized exploitation of the same. Creators are given greater economic benefit from the information and intellectual property they create, which is an incentive to create. These intellectual property rights form the foundation of doing business worldwide. It is therefore imperative that legal practitioners are equipped with skills to advise clients on intellectual property rights. So the aims of these workshops are to develop ability to advise on trademarks. So we shall look at trademarks and then see how can you advise on the same. Develop ability to protect trademarks rights, and basically what are the rights that accrue from you registering a trademark, because no one can use your trademark. You cannot now begin manufacturing cars and use the trademark of Benz. You will be sued. Actually, Wavamuno is the one who's going to first sue you. Then recognize ESCO issues relating to trademarks. Of course, shall look at ESCO issues, not passing off another person's trademark as yours, and also other ESCO issues we looked at in our professional code of conduct. So identify various forms of trademarks and industrial designs and their legal implication. Illustrate the procedure for registration of trademarks. Of course, a procedure is provided for under the Act. The Act gives us the procedure of how you register trademarks. Then illustrate the manner in which trademarks rights can be protected. So how can you protect your trademarks? Of course, you can object to the registration. You can apply for injunction. All those remedies available under the Act. Then draft documents related to registration of trademarks. We shall see most of these forms are provided for by the regulations. Also the application. Basically the forms, the Trademark Act gives you the form which you are supposed to use when you're doing a thing. So part A, bring the following items to class: a Coca-Cola glass bottle and a Pepsi cola glass or plastic bottle, an empty Guinness R glass bottle with all the logos clear and visible, a tin or container of Nivea cream, and a tin of container of Nivea cream. So A, identify the various intellectual properties on or constituted by the items above with reference to the law. Explain why they are considered to be intellectual property. So basically, we are looking at these intellectual properties. The first one is, of course, the logo, the symbol. That the logo is, or what we call a trademark, is always also an intellectual property. For example, if you look at Coca-Cola, that logo they have, which is I think in red. Then also have the bottle itself, the way it's manufactured, which we call as the bottle dress. It's also protected. Then with reference to, I'll explain why they are considered to be intellectual property, because trademark are also called to be something which can be protected under the Trademark Act. When you look at the way they are defining trademark, means anything that can be registered under this act, therefore it can be protected. So A. B. The case of trademarks, identify the parts of the trademarks register and class under which each one of them would be registered. So we have the class of registrations under the Act. If you look in the Act, you would see the classes which are there in provided of registration. You have Class A and other classes under the Act. So you enter the specific good in the class which is being provided for by the Act. When you look at these acts and regulations, you look at these classes. Then explain the legal significance of use of the symbol R and TM. So R means registered and TM means pending registration. So R, it has been registered. Then TM, it has not yet been registered. Third part B, Muchureza Enterprises Limited is a company registered in Uganda which deals in the manufacture of various bottled drinks. The company has been in existence and trading since 2017. It has since branched off into the alcoholic beverage industry, targeting local traditional drinks made by Ugandan communicates. The company has started off its local alcohol beverage product line with a drink called Inturire. It is made using fermented sorghum and honey. Inturire is a popular beverage among the Bachiga community and has been built and enjoyed for centuries. MCL has added some extra ingredients to the drink to give it a unique ginger and lemon flavor. The drink is sold mainly in western Uganda, but MCL intends to expand operations to the central region of Uganda to tap into the market of Bachiga working and living there. James Manley, the director of MCL, is worried about other manufacturers who are trying to take advantage of his innovation and make similar drinks. In fact, a company called Hot Drinks Limited has started making a drink called Spider Drink with the logo of sorghum stem on it. It is fairly similar to Enture Spider Extra Max. So basically here, as you can see, it's not registered. So if we want to protect it, the first step would be to apply for registration. So tasks 1, advise the director of MCL Company Limited on how the company can protect this brand name, prevent it from being used by other manufacturers. So basically here what you have to do is you apply for registration under section 7 of the Act, application for registration. Then prepare the necessary documents if the above process. So it's a form. They give you the form for the application which you must fill in that Act. The section also read together with the regulations. They will give you the forms you have to fill. 3, assume you are the register of the trademarks and you've been presented with documents in 2 above and take the necessary steps down the registration. So basically when you look at the sections also, they give you what the registrar is supposed to do once you have received that. So you first conduct a search, then after conducting a search to find out whether there are other names similar to that, then you also have to issue a gazette. So basically that's the process you do. From section 5, applicant for registration trademark to conduct a search, then from conducting a search to application, then also from there publication of application, under section 11. So basically that's what the legislature is supposed to do, conduct the search and then proceed to gazette it. Then part C, assume that in A above the company's trademarks application was rejected on grounds that it is similar to Spider Drink of HDR has been selling in Turire since 2020 March during the COVID-19 lockdown. HDR registered its mark in 2023. HDR sells its drinks in limited packs around the Uganda-Congo border, targeting Congolese who are fascinated by the new drink. The director of MCL has insisted that their mark in Turire Spider should be registered regardless of the existence of Spider Ding. Advise on whether and how the wishes of the director can be affected. So basically here we have what we can call one is permitted use, where you get permission from the registered person to use what? Use that same name, because you can get permitted use under section 49 of the Act. Or you can do what we call an assignment. You transfer the rights and liabilities under that Act, but through the consent of those ones who are already registered. So basically here we have assignment as well as permitted use. Part D, Super Concrete Limited is a private limited company which deals in the manufacture of a compound called Seal, which is added to cement to give it more water resistance properties when used in wet areas during construction. It also reduces the amount of cement required in construction of kitchens, bathrooms, and exposed concrete slabs. It has become so popular that so far the company has sold over 200 million bags. It is sold in 5 kilograms bags. Recently, the director of Super Concrete Limited saw an advert in the Uganda Gazette, which is being advertised for registration by another company, Buildmax. The logo is similar to that of Super Concrete and is for a product which is to be used in sealing sinks to avoid leakages. He seeks your advice. One advisor, director limited on what he can do to protect. So here you can do what we call an objection. You file an objection under section 12 of the Trademarks Act. You object for that rejection, draft the relevant documents. Also we have a form of objection, I think also supported by statutory declaration, but the section read together with the regulations will give you the form you have to fill. So assume you are counsel for Buildmax Limited, advise your client and take the necessary steps to protect its interest. So basically here you also what you do, you file a reply to the objection, which is also they give you the form and how the documents you have to fill, which are also in the Act as read together with the regulations. Then part E, assume that Super Concrete Limited and Buildmax Limited had a successful mediation which you handled using the ADR skills you learned while still a student at LDC. They have agreed to trade mutually and also cooperate with each other. Super Concrete Limited will continue to make products limited cement additives for purposes of creating waterproof concrete structures, while Buildmax Limited will limit its preparation to manufacturing sealant for Cermax, where they have also agreed to not use marks which are confusing to their customers. They are ready to make adjustments to their marks and get up as are necessary to achieve this. The two companies have also agreed to manufacture products of each other with permission. Advise Super on how they can both have their marks protected by registration. So here we have what we call concurrent use. Basically under section 27. So you can proceed under section 27 to apply for what we call concurrent use. How they can use each other's marks with permission. So advise on how they can both have their marks protected by registration. So basically here we have they can apply to do what? They can apply to be registered concurrently, because the law gives the registrar to do what? To register once you have agreed. So you can do what? You can proceed and register those things under what we call concurrent use. Then how they can use each other's marks with permission. Draft the necessary documents for two above. So basically here you also can draft documents on concurrent use if they have been allowed to do what? To use the trademark concurrently. And also the documents are provided for by the what? by the sections, by the act as well as the regulations. So you should read the regulations together with the act. So in case you want more discussion on the same, we have a discussion group and where we give detailed notes. So please, you can WhatsApp me the number in on this YouTube channel, and then I will give you further instructions in case you can afford to pay an affordable investment to support our research. Then you can be among these committed students from the all 4 campuses whom we conduct discussions online, and then we give notes. We also have a WhatsApp group where we get here from feedback from different firms. So workshop 2, any volunteer from class should sing folk song in their native language and explain to class what it means. So basically, a folk song is the song which has been passed over from generation to generation. So task 1, assuming that the clan leaders of the tribe where the folk song is adapted has asked you, your law firm, to take this folk song so as prevent it from ever being used by another person, tribe or clan without permission of the clan. Will you be able to protect it? Give reasons for your answer. Of course, you can be able to protect it because section 3 provided that once, and it's read together with section 4, once you have reduced it in writing, you can proceed to register it, and it can also be protected. However, you have to prove that it's in its original form. So assuming Ugandan musician based in Uganda, Badman attended a clan ceremony and heard the folk song in one above. As he was driving home, he started playing it out aloud and humming instruments for the song. His manager was next to him as he hummed along. The manager thinks the song would be a club banger. Advise Badman, Rasta Boy and his manager on whether they can make their hit banger and protect it under the law. So first and foremost, we have seen that for you to register under this copyright, we need originality, that there must be originality, and also something being reduced into a written form. So once you cannot prove originality, under originality, we are proceeding under the Copyrights and Neighboring Act. We have since moved out from the Trademarks Act. Now it's Copyright and Neighboring Act. So once you have to produce your song into writing, and also it must be in its original form. When we read that section 4 of the Copyrights and Neighboring Act, work eligible for copywriting, then ideas not protected, and also section 3. The also of any work specified in section 4 shall have a right to protection of the work where it's original. And to me, this song doesn't seem original, so I might not be able to protect it. What they would have to do so as to enjoy their full rights to their composition. So basically that means they have to make their own original content and see where they can stop another person from making a hit out of the folk song with variations of their composition. So basically it depends now. If the folk song is not registered, then you cannot stop another person, because this means that basically what is happening here is once you have registered your own thing, it must be in your original form. So now you have no rights over the folk song because you are not the creators or the original authors. So task 3, assuming Badman, Rasta Boy's friend Joseph Rukambo, a Congolese musician based in Uganda, was in the car with Badman, and Badman, Rasta Boy's manager in A above, he had the ideas. Badman, Rasta Boy was exchanging with his manager and security recorded them using his phone. As soon as he reached home, he pulled out his piano and other instruments and started working on the composition he had in the car. He put in so many hours of work, and exactly 1 week after beat, Badman and his manager, he recorded the song in Showbiz Avenue Studios in Bukoto, Kampala. He has since deleted the secret recording in his phone, and burnt the phone, erasing all evidence. He had not shared this with anyone. Jose Rukambo released the song and it has since become a massive hit, not only in Uganda but in East Africa. Badman, Rasta and his manager increased and are threatening legal action. Do they have a valid claim? So basically here now, of course, we shall have to go and look into the intellectual property laws first and foremost. If this Badman had registered his song and then they copied it, then that means they would have violated his copyright, like the way we saw in the case of Cautions versus Airtel. If you have read the case of Cautions versus Airtel, because Airtel was using a quarter tune of Cautions, but then he sued and then they succeeded on the reason that they had infringed his or her copyrights. Then bring the following items class: an original music CD, please ensure it has legible print concerning the composition and all the persons involved in the work, any novel in its original form, and any newspaper. With reference to the relevant law, identify all the copyright and copyright owners in the works you have brought. So basically, it depends on which original music CD you're going to bring. So it depends. If you have brought Jose Chameleon's work, that would be the copyright owner and Bang Music. Identify all the neighboring rights in the materials you have brought and whom those rights accrue. Of course, neighboring rights basically they look at broadcasting as well as music. For example, we have the lyrics, we have the video, we have the beats. All those ones are under that act. Assuming Mr. Sylvester, popular musician in Uganda, would like to redo the music composition on the original music CD you brought, he is going to use the same beats, the composition, but spice up the music with rap in English. He's teaming up with Showbiz. Advise Mr. Sylvester on the authorization. So you have to get authorization from the author of the work, from the original author of the work. What form will the authorization take? So I think it has to be in writing. Assume one of the authors in the work Sylvester is going to redo was Ewan Skmoto, born in 1900 and died in 1971. The song in question is What a Wonderful World. Assume further that Louis Armstrong was a Ugandan citizen, would need permission to redo the song. Give reasons for your answer. Of course, you would need permission to for example, from the people who took over his or her work. So it could be the beneficiaries of his estate. So you would need to get consent from them. So part C, a Ugandan artist Queen Kama is organizing a mega performance under production. She has received a notice of invitation to sue from Agropa, who have written and produced most of her songs. She has been warned against singing any of the songs without written permission from Agropa. Also want a cut from the proceeds of their show before they can allow her to sing the songs. Advise her on whether she can go ahead with the show in the circumstances. Of course, if they were the ones who wrote the songs, now it depends whether they have copyright over the same or they sold him. But if they didn't sell him copyright, then he cannot proceed and sing under the Copyright Act. Of course, we say also are always entitled to copyright protection under Section 3. Then Baram Productions on where they can sell recordings of the performance. So of course the performance of the musician, it goes to it's upon how we have agreed, but basically the musician always have the copyright. But if it depends of course on the agreement. If you agreed otherwise, then Baram can still sell the copyright. So Ugandan musician Ed Mitre, who has become so popular across many countries including England, is upset that people are copying his music illegally and selling it to Ugandans living in London and making so much money. Please advise Ed Mitre on how to stop this without having figured out England to enforce his rights. Please advise him on how he can achieve this. So basically here we have a lot of remedies that are available. First and foremost, you can seek for injunction. Then secondly, you can also ask for damages. So those are kind of remedies that Ed Mutuza can proceed under. So Uganda Mission Ed Mutuza, who is become so popular across many countries including England, is upset that people are copying his music illegally and selling it to Ugandans living in England and making so much money. Please advise Ed Mutuza. Assume that Ed Mutuza has been advised that there are many kiosks in Wandegea where his music is reproduced and sold for as low Uganda 20,000, and yet he has his original CDs that sold at 25,000. This has affected his sales. He wants this to stop. How can he stop this? So you can also go and get an injunction, or you can go and do self-help. You can go and do self-help. But we have a lot of civil remedies under the Act. We have a lot of remedies under the Act which are available for people whose copyrights are being infringed, but one is being injunction. You can seek for an injunction. So Eddie Mutanza would like to partner with Apple, the company responsible for iTunes, to sell his music online to fans all over the world. Advise Eddie Mutanza on how he can partner with App Inc. and the potential holders of rights in his work that he would have involved before he enters this transaction. So of course you can sign an agreement with App Inc. Basically to sell your work. Then also potential holders of the rights, we have you have your the authors of your work, you have the people who did the writing, your managers. All those people have to be involved in this transaction. So Part E, Uganda Broadcasting Corporation has just learned with excitement that although Multichoice has a running contract to broadcast the English Premier League in Uganda, Multichoice has decided to stop broadcasting the PL in Uganda. However, Multichoice will continue to broadcast the English Premier League in other countries in Sub-Saharan Africa, except for Uganda, which was deemed to be a poor market. UBC would like to broadcast the league in Uganda. It has no intention of broadcasting the EPL beyond the boundaries of Uganda. Carry out personal research to establish who owns the rights to permit broadcasting of the English Premier League. So basically, when you look at how those Premier Leagues are broadcasted, first and foremost, you get territorial rights. For example, UBC. For example, DSTV has territorial rights in Africa. Then you find other providers like Bein, who also have their territorial rights in the United Arab Emirates. So basically, if now UBC wants to get these rights, they have to first and foremost contact the EPL, English Premier League, but also they can also deal directly with DSTV, and DSTV can give them sub rights. So assuming that the company with licensing rights gave Multichoice exclusive rights to broadcast in Sub-Saharan Africa, how can UBC obtain rights to televise the EPL in Uganda? So you have to get sub rights from DSTV. Those necessary agreement to effect the wishes of UBC. So this is going to be a sub rights agreement. So it's form of an agreement where DSTV is giving part of their rights to UBC to broadcast in Uganda. Assuming that UBC has executed the necessary agreement to broadcast the PL in Uganda, and assume further that Radio Budu wants broadcasts to Uganda commentaries for the matches to reach persons who cannot afford television, who prefer the Uganda commentary authorization if any would Radio Budu need. So Radio Budu would have to get authorization from now UBC. Assume further that Radio Budu has obtained necessary authorization. They have identified a very handsome man, a one rare and simple Mukasipura physical fitness coach with high profile. Radio Budu wants to use his posters. So because we have Article 27 on the right to privacy and the Data Protection Act, and we have a lot of cases on MTN using other pose photos, so you have to get consent from this guy before you proceed to use his photo, because otherwise he's going to sue for the breach of rights of his privacy, and also under the Data Protection Act. Your professional advisor would like to be advised on the following. He would like to make copies of all the marks in workshop 1 which you brought to class, so that each student can have a mark in their hands during class. So we have what we call fair use. We have what we call fair use under section 14 of the Copy and Neighboring Rights Act. So under section 14, under fair use, for study purposes, you can proceed to do that. So he has also been permitted by head of subject to make copies of these workshops, be able to use them to lecture students at a new university, which starts operating in February 2025. So basically here I think we are going to also proceed under section 14 because they allow purposes of duplication for what we call fair use or academic purposes. So when you look at workshop 3, the facts of workshop 2 part E will form the facts and tasks for the moot. Moot instruction will be shared by the trial advocacy team. The detailed facts are reproduced below. Assume that you get UBC obtained rights to broadcast the English Premier League in Uganda. The rights were obtained from Marath Choice Uganda Limited. Radio Band FM has started broadcasting Uganda commentaries for the matches to reach persons who cannot afford television or who prefer the Uganda version. This is done by a presenter who sits in studio and watch the match off the television, and the commentaries are made in Uganda over their airwaves. Radio Band 2 FM pays its subscription to Uganda UBC to watch the matches on air. UBC instead of paying subscription does not allow the Radio Band to watch the match live. The matches in Uganda, Radio Band insists that it has done nothing wrong. So basically we have had a scenario of this one. I think it was in the, it happened before in World Cup where there was a ban of radios from broadcasting, I think the World Cup and also the English Premier League before they got permission from I think DSTV. And of course radios were stopped unless you had the permission from where? From DSTV. So of course there is precedence to that, but you can't broadcast audio because the law will prohibit that. So what basically you have to do, you have to get permission from that provider, not necessarily subscription. And of course I think here we're going to draft a plaint because they had a right and the right was breached. So we shall proceed by plaint to argue a violation of copyright. So basically that is it for this workshop. In case you want a thorough discussion, I was just giving you the highlights, but over the weekend I go into in-depth discussion supported by of course sections and cases with the mastermind group, and then after that we issue a detailed notice. So in case you want to be part of that group, our discussions are entirely online, and we also support students from all the 4 campuses. So please text the number on this WhatsApp group, on this YouTube channel. Then I will add you in that WhatsApp group if you can afford to pay an affordable investment of a monthly subscription fee. So please, intellectual property is not hard. It's covered by the Act. If you read the Trademarks Act as well as the Neighboring and Copyrights Act, then everything is going to be clear. So I wish you success in your IA next week.